Hello. The first case I looked at this week is a Supreme Court decision from 1850, Hotchkiss versus Greenwood. What's interesting about this case is that it set the first precedent for non-obviousness as a requirement for a patent. Up until this point, the only precedent for getting a patent involved it needing to be novel and having some utility, but this case added the additional requirement and set the standard from the court that a patent also needs to, an invention also needs to be non-obvious to someone skilled in the art in order to be patented. The case in question was over a patent regarding a doorknob and a locking mechanism. Specifically, the patent was saying that it was a patent over making a doorknob out of clay and attaching it to a locking mechanism. Doorknobs and locking mechanisms were well understood in the art prior to this patent. The only thing that it did differently was it made the doorknob out of clay instead of metal or porcelain, which were the typical materials being used. So the case eventually ended up in front of the Supreme Court after Hotchkiss tried to enforce its patent against Greenwood, and the court ultimately decided that although this was using clay does offer a utility and is a novel application, it's pretty obvious to anyone in the field that you can just switch out materials and use a different material such as clay, and it wasn't a non-obvious innovation. For this reason, the court decided to set this new precedence that an invention can't be so obvious to someone in the field if it's going to be patented, and this precedence influenced patent law for many years to come, but it wasn't until the Patent Act of 1952 that Congress put into words that this non-obvious requirement is something that all patents need to have, and that's at the point at which it actually became statutory. But in terms of legal precedence, it dates back to 1850 in this case.